Hey everyone, how's it going? Good morning, good morning. At least it's still morning here for the next 30 minutes or so. If you can hear me, if you cannot hear me, let me know. It looks like it's working okay from what I can tell. So we had some filings hit yesterday. I'm sure some of you, I know there's a couple of you that actually go and read the filings before, and then I know there's some of you that are like, oh hell no, I'm not going to read them. I'll wait until someone tells me what's going on. So I'm going to give it a few minutes. We'll catch up for a bit. Hey, Donna. Hope you're doing well. Hope everything's all right with your sister. How are you? Hey, Irish. Hey, Miss H. Hillbilly Vagabond. Sherry. Hey, Ruth. Hey, C Cat Sam. I swear a lot of times I know I'm saying people's names wrong. So I'll call you C. Hey, Princess. Hey, Aussie boy. You saw that Aussie boy? I don't know what her deal is with me. I've never spoken on her. I've always let it be. Aussie boy, I don't understand. I'll keep my mouth shut because there's no, I mean, the things I want to say are pointless, right? Like why stoop to that level? But yeah, I don't understand it. What have I ever done? All I'm doing is talking about Katie Joy's lawsuit because it is legit, y'all. If this wasn't fucking legit, it wouldn't be going on. Like, right? Um, just a reminder, if change it to all chat or live chat, whether if you're on your phone or your laptop, whatever it may be, instead of top chat. Hey, Irene. Hold on, let me catch back up where I was. I don't know anything about her, to be honest, Aussie boy. Never cared to ask. I heard things back. It's been a while since I've even heard anything. I didn't even realize that's who it was. And then I figured it out. She's so nasty. Listening as you move around. Good, Sarah Lopez. Move, move, move. Thank you for joining us. Okay. Yeah, hit that like button. Thank you, Irish. Um, yeah, thank you for the little hearts, for the likes and all that good stuff. All right, so how's everybody doing? I know I said I was gonna probably be back last week. I'm a week late. I said you'd probably see me last Thursday or Friday. Here I am a week later. We know how I roll. That's why, listen, y'all, like whenever I say that my channel is just for this right now, I don't live, breathe Katie Joy. I don't live, breathe this lawsuit. Okay. But I am here for it. And I'm ready for it to be done, just like everybody else is. So that way I can stop talking about the bitch. Because that's all I talk about. I don't get into her everyday shenanigans. We know that she does ridiculous crap. Okay. It's just pointless for me. Someone like Katie Joy is never going to change, right? They are who they are. She is who she is. And there are a lot of people that want to see her be held accountable. And what gets me is, Aussie boy, like what you're saying, is why is somebody who was dead set and obsessed talking about Katie Joy all those years ago, all of a sudden pissed off at me because I'm talking about a lawsuit? That's what the crazy thing is about the anti Katie Joy community. It's why I never got involved with anybody. I do my own thing on my own. People that have been anti Katie Joy, who have their own channels, whatever, if they come my chat, I'm going to be kind to you. I'm going to be nice to you, no matter who you are, no matter what side you're on. If you're kind in my chat, I'm going to be kind back, right? But it blows my mind watching the anti Katie Joy community, what it's done in the past few years, and it's wild to me. I've never gotten involved in it. I don't really understand a lot of it. But to come after me because I'm talking about something, what, did you fail at it? I don't fucking know. Anyways, I'll shut up. Stay out of my shit. Just pretty soon I'm just gonna block you. Yeah. Yep, Ruth. That's what I figured out. Because look, if you want to come in and you have an issue with what I'm doing, that's fine. I don't expect everybody to agree with me. I don't expect everybody to agree with our perspective over here regarding certain things. But what I do want people to understand is if you don't listen to what I have to say, don't come at me and say I'm supporting Robert Shin and that that I'm clueless to the fact of all these things, that Miranda this, James that. That means you haven't listened to one word I've said. One word. So You're back from Mexico. I hope you had a good time, Shauna. It blows my mind when you have such a large channel and then my small channel gets more views than your videos. So, I don't understand what the point is. Just don't come after me. If you don't like me, don't like me. Don't fucking watch me. But clearly you're still interested in what's going on with Katie Joy, but you're just going to come and you're going to insult somebody else because you're not covering it. I don't understand. Like, I don't understand. And if you don't agree with what I have to say, let's talk about it. Let's try to, I can absolutely reason it. But to sit there and go, oh, I can't believe you're talking about this stupid shit. Why? Because you gave up on it and because you got a dying fucking channel? Okay, and who I said I wasn't going to talk about it? But sometimes you just gotta, right? Press those buttons. I know, Shauna. But anyways, so what we left off last time with was that Katie Joy filed, let me pull that one up real quick. Katie Joy filed, well, actually, I'm just going to share this particular screen and show you what we're going to talk about. Because I'll make sure I'm still signed in here on the court website. No, I'm not. So let me sign back in the court website. Then I'm going to share my screen. Yeah, my husband's home today too, which is, so if I have to pause or something, if he walks in here. Thank you, Donna. I love it when y'all are in chat. Thank you, Irene. Hey, Wheezy. Okay, so I'm going to share this screen real quick. Let me see. Can y'all see it? All right, hold on. Let me fix this real quick. All right, so this is where you go to find the documents in case you're unaware. Okay. This is the case number, all that good stuff. As we scroll down, right? Yeah, we're about to have a big change also. I'm not going to say anything right now to y'all, but there's a change coming, okay? Don't let it freak y'all out if you see it before you hear me talk about it, okay? I'm just going to throw that out there because I don't know 100%. I haven't seen it on the docket yet. And, sometimes people tell me things. I have to make sure that I vet it. I'm 99.9% sure that it's accurate, but I don't see it yet. So, but I'm just here to tell you. Okay, so as we go through here, we're going to see what was filed. On the 11th, you can see all these things that were filed. Okay, let's go back to the 27th here, okay? This is when Katie Joy filed a notice of motion and motion. And then I noticed over a few days, like all the information underneath it kind of changed. Like there was more lettering. That motion, the memorandum, all the exhibits, none of that ever showed. So remember when we were talking on the last live, right? Talking on the last live stream. And I said, okay, well, we see what her notice of motion is saying, but there's nothing, I don't know what her argument is. So if I come back, if it's been filed, we'll talk about it. Well, nothing was filed until the 11th. And I'm going to show you what's wrong with what's being filed, and then we're going to go over with what we can view. Hey, Leanne. Oh, my gosh. I'm so glad you're here because, I'm going to have some questions for you possibly. Have you read this, Leanne, is what I'm going to ask you. Have you read any of the documents? Again, and I'm just going to say this now that Leanne's right here. As we're looking at this, okay, you see where it's the first one says affidavit of attorney, 63 pages, and then above it, it says memorandum, 63 pages. Okay, where it says memorandum, when you go to click on that memorandum right there, all it does is bring up Jennifer Moore's affidavit, okay? So we can't see her memorandum. What I'm looking at today, I'm gathering what her argument is. We're going to look at her new notice of motion, which was amended. Okay, so we're going to talk about that. We have her affidavit, we have her attorney's affidavit, and we have a proposed order. We do not, right, Lynn? I'll tell you what, my friend. I mean, it's something, isn't it? It's something. Why isn't it let me put your? What's going on? I'm trying to pin your. There it goes. Wouldn't let me pin your statement. So, hold on. I think I have a lag. Can y'all still hear me? You know what I'm realizing? When I start putting stuff up on the screen, it's delaying me. So I'm just not going to do any of that. Hey, Trip, good to see you. Okay, good. Hey, Miranda. Eating your dinner. Enjoy. Okay, so well, back to this real quick. All right. So basically, whenever we click on where it says index number 261, that's not the memorandum. Okay. That's just another, I don't know if the error is on Katie Joy's side, if they filed it wrong. I don't know if it's an error on the court's end and it was filed incorrectly. I don't know, but we don't have the memorandum to look at today. My guess is it's extremely extensive, and it's her whole argument. So what we're going to look at is what was filed, and we're going to kind of I'm going to explain to you the best that I can. If Leanne is able to give her 2 cents, if she's able to stay through here, that's fantastic too. Leanne is an attorney. She does not practice in the U.S. Katie Joy has a big problem about that. Katie Joy acts like she doesn't understand U.S. law because she's in the U.K. Right? And I know it's getting late there too, isn't it? What are you, 9? I think you're 9 hours ahead. So what about almost 9 p.m.? I guess it's not that late there. So let's get into it. We'll just kind of go through what we're able to see, and I'll explain. Hey, Christine. All right. So the first thing we're just going to go ahead and look at is the new notice of motion. All right. So she amended it. So I don't understand. It's 5:45. Oh. Oh, yeah. Okay. You're not 9 hours ahead. You're 6 hours ahead. So you're really, then we're on good time then. So this notice of motion that was filed on 8/11 is amended. Okay. Her original notice of motion basically said, look, and look, y'all may put all this in layman's terms, okay? Because my brain is scrambled. I'm just going to put it in layman's terms. I understand this is not 100% legally correct in my terminology, right? Forgive me. Again, it is what it is. But she basically said in the original one that was filed on 7/27 here, she says this all files under anti-SLAPP, and we expect this case to be dismissed. All 212 statements gone under anti-SLAPP. All right. She filed. I got to figure out which one this is. Hold on, let me share. I'm going to try to share the correct screen. I got to make sure I have the right one. Okay, so notice of motion. All right, so we're going to start with this one. I'm assuming y'all can see that well enough. Does that help? Let's see if that helps. Yeah, I don't know why I said 9 hours, Shu. Like, I'm fully aware it's 6 hours. I don't mean my brain. And like I said, my husband's home today too. We have a lot of stuff kind of happening at once. So he'll be home he's working from home for a while. Oh, she's up to no good, Christine. You expect her to be up to good? All right, so here is the amended notice of special motion and special motion for expedited relief pursuant to Minnesota Statute 554.09 and for attorney's costs, fees, and costs pursuant to Minnesota Statute 554.16, which is the statute for summary judgment. Oh, I'm sorry. I mean for I'm calling it anti-SLAPP because I get tongue-tied when it comes to the UPEPA, right? UPEPA, like, so we're calling it anti-SLAPP, but that is Minnesota's anti-SLAPP, right? Okay. So the original one said it's all being anti-SLAPP. What she did in this amendment is add a few things. And what she's doing basically here is she is trying to, y'all, if you hear my mic go out, let me know. What she's doing here is now she is opening up room. And my interpretation is because she knows that she's in a bad place. And so she's opening up room for an appeal. Okay. And when it comes to anti-SLAPP, right now, keep in mind, they filed this new amended complaint. The judge granted it. It is in play now. Okay. It superseded the original complaint. Now it's these 212 statements. We've been talking about these 212 statements slowly. I've done the videos on all of them. You can go through and you can watch all the statements that she has said and typed, all the slander, right? And all the libel that she's done. We're going through those. So this new complaint is 212 statements. So we're going to look at what Katie says about it, what her attorney says about it. But the first things first is she's filed this notice of motion and motion. However, the memorandum's not there. The motion's not there. So I can't get into her full argument. Hey, everyone. Can't believe I caught a live finally. Thank you, Southern Mutton, for keeping us up to date. You are welcome. You are welcome. All right. So basically in this one, she's saying, okay, that she wants the judge to just dismiss this from anti-SLAPP. She's saying she's protected, right? Free speech, journalistic privilege, all these great things. And that if the anti-SLAPP was in play back in 2022 when she was served, this never would have happened. But now that the anti-SLAPP came into play while this was in litigation, halfway through basically, it came into play May of 2024. Keep in mind, the docuseries came out May 31st of 2024, and that's when her statement started to get really bad because she was basically like, I'm vindicated. All this can be dismissed, right? This is all going to go away, but it hasn't. And then she's like, okay, well, since I've said all this dumb shit, I'm going to be covered by anti-SLAPP. So, hey, Jill. Hey, Ginger. I didn't say hi to y'all yet. Basically, she's saying that, look, I'm covering matter of public concern, right? And therefore, anti-SLAPP applies, the Minnesota anti-SLAPP. And then she said, okay, so basically, I'm just going to skim this. Take notice. Okay, so remember, the next hearing is on September 8th, okay? Oh, I can't do that there. I have to do it here. Hold on. The next hearing is September 8th. All right. And so this will be discussed. And she's saying basically that she wants, the courts to look at this from the anti-SLAPP perspective. But then she's saying, well, if that doesn't apply, like basically if you deny my whole anti-SLAPP argument, then I want you to look at it through the summary judgment perspective, right? And then also dismiss it. So if you don't dismiss it through anti-SLAPP, so at one point I really thought she was going to file another motion for summary judgment, but we have deadlines here. The deadline's August 31st. I don't know if the judge might eventually, it depends on how this judge rules on this. First of all, what's going to happen next. Okay. Because there's different ways that she can rule this. Do I think she's going to completely grant Katie Joy's special motion to dismiss? No, I personally do not. I don't know. Leanne, if you want to weigh in on that, please feel free to do so. Do I think that she's going to grant it? No, I don't. Do I think that it will probably be granted in part and dismissed in part? Yeah. Do I think, we're under, we'll see, right? So basically that's what she's saying. But this amended complaint now, she went back and she's adding kind of some more layers. What she's doing is she's really trying to be able to pad herself, to protect herself in a way to where now she can actually go and file, hey, Kitten on the keys, go back and file. I'm sorry, she can appeal this. Okay. That's kind of where this argument is. Hold on. I think I got a dog trying to come in my door. Hang on a second, y'all. Okay. I guess he's not trying to come in. My husband's home, so normally. All right. So basically, anti-slap, if that doesn't work, then use the ordinary dismissal summary judgment. Okay, keep in mind when you anti-slap. So what this did when they filed this new amended complaint, it reset everything in motion to where anti-slap could apply. Okay, in Katie Joy's mind, it does apply, but it could apply. You think it'll likely be granted in part and denied in part? Yeah. Thank you for that, Leanne. With the anti-slap, it automatically allows you to appeal. Okay. So because this has been set in play, the whole new amended complaint supersedes the old. So now you kind of have some new terms. Because since then, the anti-slap has been brought in, Katie Joy's argument is it's going to fall under anti-slap. Well, under anti-slap law, number one, if it's granted, you are awarded all attorney's fees. Okay. That's, again, Minnesota's anti-slap is a little bit different than the ones I'm more familiar with, which is like California. But also it allows you to be able to appeal, where a typical order to dismiss, like summary judgment or whatever, she wouldn't have that opportunity. So she's taken advantage of that because she's feeling that the appellate court's going to do something for her. And you're going to see what Jennifer Moore included in her affidavit, and it blows my mind, y'all. Like, it blows my mind. Hey, gingerly listening while reorganizing. Glad we can keep you company. KJ loves for families to be broken apart more than anything. The family unit is the most dangerous thing to these people, in my opinion. It is the core of a strong society. I agree, St. Elmo's Fire. So we have to keep in mind now, she's like, okay, you restarted this, you reopened this. So now, if the anti-slap doesn't apply, then, I want you to, but I just want to give you a reason. I just want to explain why she feels like this can be amended, why this can go to a court of appeals. And that's because of the anti-slap. Okay. So she's basically saying all that. We're just going to kind of skip through. Defendants further move for an award of cost, disbursements, and reasonable attorney's fees and litigation expenses pursuant to the anti-slap statute. And then she's saying, in the alternative, like I just said, if this doesn't apply, if the judge says, nope, dismissed for anti-slap, then the defendants move for dismissal of that cause of action under Minnesota Rule of Civil Procedure 12.02 and 56, which is summary judgment. Now, remember in one of her other motions, she requested that the court certify a couple of questions to the appellate court for review. The judge denied that. The affidavit was so comical. Okay, I'm glad Leanne. I laughed for a long time. Now I read that case study they included, okay, which we're going to go over that in a second, y'all. What Jennifer Moore included in her affidavit, what she included, number one, it doesn't even apply here. The statute is from Virginia. The statutes are two completely different statutes. They just don't, and I'll go over all that in a second, but I read it in full. It was fascinating, actually. It was actually a really good read. I enjoyed it. So if y'all are weird like me and you want to read it, I'll show you where to find it. But we will go over it quickly here in a bit. So now she's asking again, right? That she's saying basically, she's, defendants further request that the court certify the following questions for immediate review as important and doubtful under Minnesota Rule of Civil Appellate Procedures 103.03. To the extent any portion of the court's rulings does not fall within defendant's automatic right of appeal under Minnesota statute, the statute of anti-SLAPP. Again, I'm calling it anti-SLAPP. That's not how it's worded in Minnesota, but y'all just have to deal with me. All right. She has 3 questions. And the way I'm gathering this, and Leanne, feel free to please put in your 2 cents if you're willing and if you're listening still, because I'm not an attorney. I'm a paralegal. I was a paralegal many years ago, many moons ago. So sometimes I can't be as detailed about it. I can just give what I'm reading, and I can't give forethought or, like a procedural standpoint, like what they might be thinking about doing. Like I can't, sometimes I can't offer that. I can try, but again, it's not from an attorney's perspective. But what I'm seeing here is basically she's saying she's trying to find all the avenues to be able to appeal this, regardless of how this judge rules on her motion to dismiss, her special motion to dismiss. And obviously, if she grants the special motion to dismiss, this all goes away. Okay, if she just grants it in full and says, yep, it's all gone, all 212 statements dismissed, you win, and you're awarded attorney's fees, obviously there's not going to be an appeal on Katie Joy's behalf, right? But she's wanting this district court, to certify for immediate appellate review these questions. Question 1, whether a district court has a constitutional obligation to independently assess whether the evidentiary record is sufficient to support a finding of actual malice by clear and convincing evidence before permitting a public figure's defamation claim to proceed past the special motion stage under the framework established by, and then she gives, her case studies, whatever. I did not read those. So I'm taking it as they're asking Judge Willis, like they want to know whether or not this court can independently decide the actual malice evidence, right? Like, does she have the authority? I mean, I don't know. That's kind of what I'm getting here. And that she can decide whether or not the plaintiffs have enough evidence for it to go to jury. Now, keep in mind too, y'all, we've already seen a lot of similar rulings on this, and I'm going to go back and show you her ruling on the when she granted the motion to amend. We're going to go back and look at some of that. Yeah, Christine. Yeah, we're going to get into that when we get into Katie's. Katie's like, this is too expensive. And then her attorney's like, this is too much. This is going to confuse the jury. This is way too much. We just got to let it go. My client said so much bullshit. It's going to be so confusing to the jury. Therefore, just let it go. Okay. So, but I have to make it very clear here what her argument is. Now, again, I can't see the memorandum, so I don't see her exact argument, but I can tell you what her strategy is. And she has every right for this. And also by me doing this, it'll help explain why her attorney in the affidavit referred to this one case, because it's all about referring back. Okay. And we've already talked about that. We'll get into that again. So that's question number 1. Question number 2, whether Minnesota's Uniform Public Expression Protection Act, okay, they're anti-SLAPP. So it went into effect May 24th of 2024, and the docuseries was released on the 31st. That's crazy. And specifically, the savings clause set forth in that statute applies to a cause of action first asserted in a complaint filed before the act's effective date, where the cause of action is later repleted or specified with greater particularity in a complaint amended after the effective date, and if so, whether that inquiry is resolved on a claim by claim or statement by statement basis. Okay, let me remind you of something. Katie Joy was sued in 2022. New amended complaint comes out February. Well, the motion to amend complaint was beginning of February 2026. Okay. There is a very strict statute of limitations for defamation in Minnesota. That's 2 years. So the motion to amend the complaint was filed beginning of February. That would take you back to anything Katie Joy said prior to the beginning of February of 2024. That would be considered outside the realm, right? It's outside of limitations. It cannot apply. Okay. Katie Joy is also trying to argue that whatever fell before this anti-SLAPP came in, right, May of 2024, and preceding February of 2024, if that makes sense, anything between that and whenever she was sued in April of 2022, anything in there falls within the statute of limitations. That's another argument. Hey, SD. Yeah, let's throw everything at the wall and see what sticks, right? So does that make sense? So there's multiple arguments. That's what I have to make clear to y'all, is that there's the one argument of anti-SLAPP. Okay, so that came in. Then there's the argument of, well, there's some time barred stuff because the defamation, statute of limitations for defamation, that would apply that anything before February 2024 was said falls outside of that. Now, they already tried to talk about that. We'll go over that in a bit whenever I look at the judge's ruling on when she granted the motion to amend. She basically said it all applies because there's certain standards that have to apply. One is, saying all of this relates back to the original complaint. They're not adding new people. They're not adding new parties. They're not changing up all these wonderful things. It all relates back and is very strictly related back to the original claim, if that makes sense. Okay, so that's another argument she has. So this question number 2, basically what she's wanting to know is, since they've come back in this new amended complaint and rephrased these things from the very beginning, if that makes sense, that was in the first one, does that reset it? I guess is a word. I don't know how else to put it. Like, does that reset it to the beginning and then fall under the statute of limitations? So they're saying, like, we want an appellate court to determine how to rule on all this because we've got the anti-SLAPP, we've got this statute of limitations. So whenever they came in with these new statements and then they reworded some of the statements that were in the original complaint, do those apply to the anti-SLAPP? So you can see what she's doing. She's opening these avenues to be able to appeal this. Hey, Suzanne, what is her major malfunction now? How much time you have, Suzanne? SD says, I'd be incredibly insulted if I were a jury member and read that motion. Does she think they're going to be too stupid to listen? Oh, yeah. And we haven't really, I'm assuming you've already read it, SD. And that's when we're going to get into what her attorney, her affidavit. But again, hey, Zuna. Again, I just want to kind of give through what she's arguing and what we can maybe anticipate to see what's going to happen. Okay. Then her question 3 is whether under Minnesota's statute, anti-SLAPP statute, a responding party's burden to establish a prima facie case as an actual malice requires a showing of sufficient to permit a reasonable fact finder to find actual malice by clear and convincing evidence consistent with the framework described in question 1, or whether lesser evidentiary showing satisfies that standard at special motion stage. So what she's saying basically is all going back to malice. And she's saying that they cannot prove actual malice. And so she wants some clarification from the appellate court prior to this. Now, she already asked the judge to, and it doesn't show it in here, but she already asked the court to certify some questions to the appellate court prior. The judge denied that. So we'll see what happens. So let me scroll back through here. And that's the end of that. Okay. So basically what she's saying is, let me just summarize that again. This is her notice of motion for the motion, but the motion's not filed. And I'm going to go back and double check here in a minute, make sure that while we're on here, it doesn't appear. As I was showing you earlier, what shows whenever you click on the memorandum is just another filing of Jennifer Moore's affidavit. So I don't have the full argument, but I think we can kind of tell this argument's going to be. Hey, Zuna, thank you so much for sending a gift. I wish I could see those. Why can't I see them on my laptop? Sounds like she's putting the cart before the horse. Sounds to me like she got somebody else with some more knowledge to help them with this because her original notice of motion was just like, yep, this all falls under anti-SLAPP. Now I see why thank you again, Zuna. The memory. Okay, thank you, Leanne. Yeah, still, when I just looked a few minutes ago, it's still not filed. Do you think that's, in a situation like this, Leanne, do you think that's an error on Katie's part or the court clerk's part, like the court? So all I can do is just show y'all what's filed. Okay, so now we're going to start with Katie's because we're going to start with Katie's affidavit because we can probably get through that pretty quickly. Let me see. Does that show? Whenever I try to watch it through YouTube, I have a delay. Okay. So here's Katie's declaration, and it is 21 pages. Hang on one second, y'all. Who's out there? Hang on. I'm going to mute y'all real quick. Is he trying to get in?
No.
Oh, it is? We're all good, babe. Thanks. Okay. All right. So now we're at Katie Joy's. I guess my husband not able to do some stuff because I'm stealing all the Wi-Fi. The luxuries of living in the country, right? All right. So again, we've seen this before. Okay, so it could be the attorney error or the court error. It's incompetence either way, but I bet Jennifer fluffed up. I agree because we've seen so many errors on Jennifer Moore's part, haven't we? How long have you been following this, Lynn? When did you start looking at it all? Because there's been a lot of errors. Where's her journalism degree? The same as where her doctorate is, where her degree in biology is, all of her other degrees, it's in the same place. Nowhere. You started following KJ went after you. Oh, that's right. Okay. So that's right. That makes sense. I just didn't, I guess I don't know where that was in the complaint, like where they were in litigation as it stands. So Katie Joy says, I'm a defendant in this matter, and I make this declaration in support of my special motion to dismiss under the uniform, okay, whatever, anti-slap. I swear I get tongue-tied whenever I try to say Uniform Public Expression Protection Act, right? That's just too much for my mouth and my brain. I have personal knowledge of the facts stated in this declaration, could testify competently to them if called as a witness. Well, you can pretty much bet your ass you're probably going to be called as a witness. Basically, she says, I incorporate by reference the facts concerning my background as a journalist, my sourcing methodology, and the identification of my sources set forth in my declaration, dated December 9th, okay, in support of her motion for summary judgment. She's saying that the matters concerning the plaintiffs that she's reported on are extensively covered by other media outlets. Many of my sources have verified my reporting and interviews, and that I just don't know. I disagree. Everything that I've looked at, everything I've read, I disagree. They all come after the fact. They all follow Katie Joy's narrative, if that makes sense. The Netflix documentary provides extensive corroboration of the statements I have made. Okay. Again, Katie Joy's narrative. Does it really? The record in this case is replete with independent evidence that I am not targeting plaintiffs because I wish them malice. I am reporting on them because what I say is newsworthy. Okay. Bullshit. So then she brings in that on July 25th of 2025, the FBI and other federal law enforcement agencies executed a search warrant related to an investigation into 7M Films and Robert Shin concerning allegations including sex trafficking, money laundering, and mail fraud. A related federal civil forfeiture proceeding remains pending as of the date. We've talked about that on here. What's happening with the money that was seized during the raids of Robert Shin's properties. Again, there's been 4 stipulated agreements to extend the deadline, and now the last extension has been extended to October 4th. It'll say it somewhere in here. I believe it's the 4th of October. April 2025. So it's been a little over a year, huh, Leanne? Hey, Purple Dragon Shill. What she says is only newsworthy to her. So, we've talked about what's going on with that. So she's using that. She's still hoping up, because keep in mind, it has been extended again. And that is for him, that there's a possible indictment. Doesn't mean he's going to be indicted by, like, if something else happens with this case, doesn't mean he's going to be indicted. But the deadline for us to know is October 4th. I agree, Suzanne. I agree. Her lawyers seem to be very incompetent. Yeah. So basically what I'm going to try to go through this pretty quickly. She's saying that because the FBI, the FBI investigation corroborates everything that she has said, and that, the plaintiffs have acknowledged this in their California lawsuit, their other civil lawsuit in LA. And she, attaches that as Exhibit A. It's the affidavit, saying, oh, yeah. She remember when she tried to tell the court, Robert Shin is denying that he's under federal investigation, but here's proof. It says it in this civil lawsuit in LA. And 7M is like, he never denied that he was under federal investigation. It's a special motion to dismiss, which under the it is an anti-SLAPP law that has been implemented in Minnesota, but that didn't take place until May of 2024. And this obviously had been in litigation for quite some time. Yeah, Suzanne. Katie Joy went after Leanne. Went after her. You know how Katie Joy does it, Suzanne. She was pissed off that Leanne had any say and opinions regarding Blake Lively, because Leanne was covering the Blake Lively, Justin Baldoni thing very closely. Katie Joy didn't like it, and she had to insult her and try to dox her by saying, look, she's not even in the U.S. She doesn't understand our laws, because Katie Joy is an attorney. Yeah, that's her MO. See? Hang on a second, y'all. All right, I had to adjust myself. Okay, so she's saying that all of this stuff, right? So she lists that as it's Exhibit A. We know of him, his attorney in LA saying that he's under federal investigation, suspected of these things. And then, okay. So then what they've done is here. Okay. So what she says 6 is I make the statements below organized by 4 categories. And it's what we just kind of talked about. Statements first pleaded in the original complaint that the court has already ruled on, or they're now specified with additional detail in the Second Amendment complaint. Okay. So that's the statements that were in the original complaint. I think in my video yesterday or the day before, I said 87 statements. There was 85. Nonetheless, 80 something, right? In the original complaint. Then there are what we just talked about. There are the statements published before February 4th of 2024 that were never part of the original complaint. And what she's saying is that applies to, they're time barred, right? That's saying that this falls outside the statute of limitations because the motion to amend the complaint was February 2026. There's a 2-year statute of limitations in Minnesota. So anything prior to February 4th of 2024, if it was not included in the amended complaint, if it was not included in the original complaint, it's time barred and it doesn't apply. Then the next category is statements published between February 4th and May 23rd of 2024. Okay. And then all the statements published after May 24th of 2024, which is when the anti-SLAPP in Minnesota came into play. Okay. And we've talked about this for a long time. Before this even came out, we assumed this was what was going to happen. We kind of came to all of those everything that was going to happen, and it did. So, oh yeah, she also called out Popcorn Planet. She's called out so many people. So many people. Yeah, Jill B. And that's another thing. I'm still trying to work on some other things regarding like that, about how this whole snowball effect, as you just put it, which is a good way to put it, when she started talking to Miranda's family, and then her narrative took hold, right? And then that turns into other outlets kind of taking her narrative, but they're not stating it as fact. These other outlets just said, yeah, he's being accused of, or these accusations against, or alleged, whatever. They didn't state it as fact like Katie Joy did. I know, Leanne, that whole thing with Zach really kind of blew my mind. Could the channel's revenue be awarded as damages, since that is all in places she defamed? See, and then I read your comment because Christine says, so Katie Joy's very careful about what she puts on YouTube. Most of her stuff where she really blatantly states things as a fact. Now, she did a couple of it on YouTube, and you're going to see them in the videos. And as we go through them in the live streams, as we get to those YouTube videos where she does kind of state some things as fact, but she's careful on YouTube. Most of her stuff is said on TikTok and Instagram. Tripping Gauntlet, I did have a great trip. Thank you. It's good to see you too. I did. It was very relaxing. My husband and I had a great time. We needed it. It was well deserved. For him, mainly. So she's saying, as the statements first pleaded by the original complaint, whether dismissed by the court's June 23rd, 2025, and December 17, 2025 orders. Now, that's when that was the ruling on the summary judgment, right? And some were tossed. Some were, well, yeah, I can see why you're arguing this, but 7M, you can move the court to amend the complaint. And that's exactly what they did, and kind of put Katie Joy in a worse position. So then she goes through the statements published before February 4th that were not part of the original complaint. So she's saying the Second Amendment complaint also identifies statements published before February 4th, which again is the statute of limitations deadline, that were not part of the original complaint. These statements were based on my review of public court records interviews with former members of the organization plaintiff Shin operated, and my own observations of publicly available content. And she's going to have to show that. Hold on a second. I'm about to cough. Hold on. She's going to have to show all that. And, I don't see anybody coming to her aid and being like, yeah, I told her all this stuff. All this is true. I don't see that happening. I don't see how she's going to be able to prove any of this shit, but whatever. Where I characterize conduct as resembling a cult, described conduct as alleged, she did sometimes, or otherwise offered my opinion. And this is where she's trying to say, look, none of this was with malice, okay? This does not apply to defamation. I did not do this. They're wrong. They can't prove anything. This was just my opinion. I said it was alleged, right? I was doing so based on the information available to me at the time and my genuine assessment of it, not with knowledge that any statement was false or with reckless disregard for its truth. What about you talking about, for instance, James and Miranda's marriage? You went on and on saying they were not married, even though you knew that they were because they told you that they were. Then whenever you finally got copy of their marriage through Discovery, you went and put it out on social media. But not only did you do that, you said with a fact, as a statement, you said it as a fact that it was forged. And then she implied that Shirley was the one that forged it. So it's not accurate. So then she went back because she thought she was being covered by the anti-SLAPP. She thought that the raid of his home, because she did that on the day he was raided, she put out their marriage certificate that she got through Discovery. And then she said that it was falsified because it's not accurate, it's not real, it's not legit because it was forged by Shirley. Okay. So how are you saying, now she is talking about the prior dates, right? But still, nonetheless, she's going to say the same sentiment all the way through for all these 4 categories that we just went over. But that's just, how are you going to get out of that, Katie Joy? She thought that it was going to go away because he was raided, he was going to go to prison, and this case was going to go away, and it hasn't. She basically got the information from former members, informants, or public records. Like, who are your informants, Katie Joy? Who is willing to come to your aid and say, stood up on that stand and say, I told Katie Joy, as a fact, Robert Shin is a sex trafficker. I told Katie Joy, as a fact, I was SA'd by him. Hey, hot tea drinker, thank you so much for the gift. I appreciate you. Like, who's going to come tell you all this stuff? She got it from marriage records. What marriage records? Remember whenever Katie Joy said, I cannot find the marriage records anywhere. Can't find them. I've searched high and low because in California, they can be hidden. Okay? They don't have to be public record. And she couldn't find them. So she told everybody that because she couldn't find them, they were not married. Then when she got it through Discovery, she put the information out there. Then the day that he was raided, hold on, if I'm making much noise, I'm sorry. The day that she was raided, sorry about that if I made much noise. That he was raided, she's like, yeah, they're forged. They're really not, even though I said that they were legally married because I had to, because I got it in Discovery. Now I'm going to say they're not because I think he's going to go to prison. Thank you for sending the jewels, hot tea drinker. Hope 7M wins this lawsuit because Katie Joy needs a reality check. Jill B, thank you so much. A member for 7 months. I appreciate you so much. I appreciate you. I appreciate you. While I collect myself, hang on.
Thank you so much, my mutton friend. Just remember that I would not be here if it weren't for y'all. And for that, I love you so dang much.
So then she says, where I attributed information to former members, informants, or public records, including statements concerning financial arrangements, marriage records, and plain business dealings. I did so because That is where the information came from. I did not fabricate sourcing for any statement identified in the second amended complaint. I think 7M has a strong argument in this. I think she's going to be proven wrong. I did not become aware of any facts during this period suggesting that my reporting on plaintiffs was false. To the contrary, I believed then and continue to believe now that my reporting was substantially accurate. Bullshit, Katie Joy, bullshit. So then she goes in through the statements that were between February 4th and May 23rd, all of 2024. It is a small number of statements. I think if I'm right, it's like 7. She's saying the same thing where she got it. But here she says she also, was able to get it through her continued reporting on the Wilkins family's efforts to reunite with Miranda Derrick, drawing on court records, reporting I had already gathered, and my communications with Miss Derrick's family, meaning the Wilkins. So this is one thing I want to know. Who are the Wilkins going to come to her aid? They're going to drop her like a hot potato. I do not see. And then is she going to turn on them like she does everybody else? It's going to be interesting to see, isn't it? It is going to be so interesting to see. Thank you, Jill B. As with the earlier period, I did not publish any statement during this window that I knew to be false. Okay, so she just keeps saying, like, I didn't know it was false. I didn't know it was false. I'm just reporting what I was told. How are you going? But see, this is where, as a juror, how do you not go, wait a minute, aren't you calling yourself a reporter? Why are you saying these things as fact? As like how and where we're at right now with the statements, the video I just put out 2 days ago, I guess. I forget what numbers they were of the statements. It was like numbers 140 through 160 something, I think. They're continuing my brain to like just get worse and worse as time goes on, because you can see she thought anti-SLAPP was going to cover her. It might, y'all. We can't say that it won't, or that he was going to be in prison. Hey, Lamb Chop, how are you? So she's just saying, again, during, my own experiences, this is important. She says, during this period, my report included my own experiences responding to this litigation and to threats and harassment I have received in connection to my reporting. Calls from members of the public to contact law enforcement agencies, including the Los Angeles District Attorney's Office, the Los Angeles Sheriff's Department, the FBI, and the IRS regarding the conduct I had reported on. So she's admitting that, yeah, she called for the public, for members of the public to contact all these agencies. But, remember when she said you need to contact them and demand to have Robert Shin arrested and held accountable? And then she says, fair and accurate reporting on the federal raid. No, it was not fair and accurate. She said a lot of things that were inaccurate. Subsequent search warrants. Okay. The search warrants are sealed, y'all. Sealed. Grand jury proceedings. She shouldn't know anything about grand jury proceedings, right? And deposition testimony given under oath in this and related litigation. So it's another thing she's done, y'all. She has given out information that happened during these depositions. These depositions in this case are sealed. Katie Joy, in one of her motions, she wanted the judge to make the depositions public. The judge denied that. Katie Joy talked about what these depositions entailed. What was said during these depositions by each of the plaintiffs. No, she never reports both sides of the story. She only reports the side that's going to benefit her and what suits her narrative. So every statement I published during this period concerning the conduct of plaintiff Shin, 7M Films, or the organization he operated was based on information I'd gathered from former members, court records, law enforcement sources. Who are your law enforcement sources, Katie Joy? Who? Do you have an FBI agent that's going to go sit up on the stand and be like, yeah, I told Katie Joy Paulson without a crystal ball everything that was going on in this sealed federal investigation? publicly available reporting by other journalists, which there wasn't. Katie Joy is the one that spearheaded all of this. And she says it. Look, if you're watching the videos that I've been putting out with the statements that are included in these 212 statements, she says, I broke the story. When I broke the story, I'm being sued because I broke the story. But now she's saying, oh, no, I got it from other journalists because other people were covering it. But you say you broke the story, that you created this narrative. But now all of a sudden, no. I got all this information from other people. I didn't make shit up. I did not publish any statement during this period with knowledge that it was false or reckless disregard for the truth. Bullshit. I understand that search warrants are issued upon a showing of probable cause. So she's saying, look, obviously he's done something wrong because they wouldn't do a raid if he hadn't done something wrong. And then she says, although the federal investigation has not resulted in charges as of the date of this declaration and has also not been concluded, and I view it as corroborating much of what I reported. No. And they're going to be able to prove that. 7M has already done a good job with kind of proving that. Mopping the floors, says Lamb Chop. Oh, more storms. Yeah, for those of you in storms ways, you still don't have electricity. Oh my gosh. Yeah, maybe it's FBI Steve that's going to come up on the stand. So I don't know. Now here's the woe is me. Remember all the times that she said, I don't care how much money I have to spend. I don't care. I'm in this for the truth. I don't care how many times I'm threatened. I'm not backing down. Now she says this litigation has imposed and continues to impose substantial financial and personal costs on me. I have incurred significant legal expenses defending against plaintiffs' claims over more than 3 years, and I have experienced harassment, threats, and attempts to have false reports filed against me in connection with my reporting on plaintiffs. What about the threats and harassment sent to Miranda and James Derrick, huh? They had to leave social media altogether. What about their financial impositions? They lost their income. You're still on here making fucking money off of other people's issues. I make this declaration to support defendant's position that the statements identified in the Second Amendment complaint concern matters of public concern. Okay, so here she is, like, anti-slap. This is matters of public concern, y'all. Were made without actual malice. I think that 7M has proven so far that it could be, that it could be considered defamatory, that she acted with actual malice. Therefore, a jury needs to decide. I think the same thing's going to happen. I think the judge is going to go through these statements. She's going to grant some, and that's really not how it works. But in layman's terms, let's just kind of look at it that way, that she's going to grant some of them, she's going to dismiss some of them, but that this new amended complaint is going to consist of X amount of statements, probably not 212, that will end up going to a jury. And what Katie Joy is saying is, if you do that, if you deny me in part or in full, whatever it may be, whether you deny it in full, you deny it in part, and grant it in part, I still have the right under the statute, the anti-SLAPP statute in Minnesota, to appeal this. Okay, so that's what she's laying this foundation for. So here, she's trying to say, look, this all falls under anti-SLAPP. They cannot prove malice, and all that. So then her Exhibit A is this filing that's in regards to the civil case in LA. As you can see here, the plaintiffs and the defendants. Again, this is the two, Alicia and Melanie are the two past members of Shekinah that have known and had personal relationships and friendships with Robert Shin along the way. Then these others are other bloggers that are on Instagram, and he's suing them for defamation, same thing. So yeah, in here it mentions that he's under federal investigation. This is when he filed in LA, filed for a stay in that case because of his federal investigation. And Katie Joy is like, see, he's under federal investigation. See, he's under federal investigation. I told you, Judge. I told you. He tried to deny it. He's denied it. He's never denied it. He never denied that he was under federal investigation. Oh yeah, Christine. And again, if you watch the videos that I've been putting out and that we'll cover on the live streams, we're starting to get to those Instagram lives and TikToks. And I just don't think that there's any way somebody's going to go, oh yeah, she didn't say that with malice. Like she didn't act with malice on that. How can you say with 100% certainty? And we're about to look at Jennifer Moore's affidavit right now, which Leanne even said just brought her giggles. Like this is just, y'all, I laughed my ass off. I'm not gonna lie. I'm like, what am I reading? What? This is ridiculous. Okay. And what she brings in there goes back to whenever Katie Joy says on a TikTok live, Robert Shin is a serial rapist. Hey, Skynet, thank you so much. Hey, Mama Celeste. Thank you, Skynet, for that. Mama Celeste, welcome to, what are we now? You're a Mutton's cousin? You're a Mutton's cousin? Thank you so much for that.
Thank you for the love and the money. While we keep covering this dummy, it keeps this little channel growing, so we can keep this crazy going. From the bottom of our hearts, we love you so dang much.
So here, as we go down her exhibits, her exhibit B is this stipulated agreement to extend the deadline on this civil forfeiture complaint. We've talked about this on lives. I've done a video on it. The latest one extended this to, let me see. I believe it's October 4th. Anyways, basically what she's saying is, because there was one for July 6th, and then it was granted again until October 4th. Okay. So basically all she's saying is, look, his situation is not done yet. Okay. He has not been exonerated of anything. He's still under federal investigation. So everything I'm saying could be true. If that makes sense. Oh, she is Skynet spending oodles of money on this lawsuit. I don't see this being dismissed. I see parts of it being dismissed. But Katie Joy's argument, that's what I want to make very clear here, is she amended her notice of motion that she filed back in, a couple weeks ago. She refiled it on the 10th. Again, we can't see her memorandum because there's an error in filing. We don't know if Jennifer Moore made that error or if it's an error of the court. Nonetheless, we can't see the full memorandum. So we're just kind of going over what's filed, right? But y'all, okay, so now we're going to go to Jennifer Moore's declaration. And honestly, y'all, I could be wrong on this. I think this is her 13th. She made an error before regarding the number of what declaration it was. I could be wrong, and that's okay. I'm known to be wrong. I think it's her 13th, but that's neither here nor there. Yeah, Jennifer Moore specializes in family law. And one of the reviews says they wouldn't even let Jennifer Moore represent their cat. That was literally one of the reviews on the website, or or on Yelp, something like that. Thank you so much, Donna, for sending the jewels. I appreciate you. Yeah, Katie Joy is not just going to walk away from this. But what she's doing, and that's what I just have to make a point here. Sorry if I make some noise here. Hold on a second. What she's doing is she's basically saying now that because, again, by filing this new motion to amend, filing this, and then it was granted, now it's an amended complaint, that is in play. It supersedes the old one, right? And with that, Katie Joy can file a motion for, a special motion dismissed because of anti-SLAPP. Right? And because of that, and because of that only, at this stage, the statute allows you to appeal. So she's saying, you know, no matter how you kind of rule on this, we're finding a way to appeal it. And she gave those questions that she wanted certified. She wanted Judge Willis to certify. She wanted to ask these questions to the appellate court, and Katie Joyce tried that route before, and the judge said, "No, I've got this covered." Okay, now this is where it gets funny, y'all. She has a 1-star rating, I know. And, you know, I think someone even said at one point if they could, you know, it should be 0 stars, if that was even a possibility. I think it was about a year ago, Maya, when she said that she's already spent over 200,000. Like in the very beginning, she was like, yeah. Like I remember when they right around the time that they changed judges. So it was like after it was like February of 2023. It was like a bunch of motions had been filed, and they were all ruled upon in February of 2023. Right around that time, she had said she'd already spent like $30,000. Then when it came to, I think around the time a year ago, into July, when he was rated, I think is when she started talking about how she spent over $200,000 so far. So I think that's been a year ago she said that. Thank you, Leanne Newton. Look, if you can get on Todd Chrisley's good side, right? Tell him we're waiting for you, Todd Chrisley. We're waiting for you. Okay? We're waiting for you.
Truth will rise just like the sun every day. 2 things you can be guaranteed of is that the sun's going to come up tomorrow and that the truth will be revealed. And it's going to be revealed about you, YouTuber. I understand she gets upset, folks, when you call her a YouTuber.
That'll never get old. That will never get old. That was before he sued her. Way back when. Call her YouTuber. Yeah, he needs to circle back around. We're all thinking, Leanne, that he's gonna get her while she's down. That kind of seems like his MO, his style. I think he's going to. I honestly think he's going to. The shit she said about him while he was in Skynet. Thank you so much. Another Skynet, you received your own gifted membership. Well, congratulations, Skynet. Thank you for that. Welcome. Welcome to Mutton's cousin. That's so funny. All right. So yeah, the things that she said about Todd Chrisley when he was in prison were well beyond the realm of what she had said prior. They were bad. I've done videos on him. If you have not watched those videos to see what she said, go back and take a look, honestly. Skynet just sent another one. Love in the Laundry. Welcome. Welcome to our channel memberships. Oh, you know what, guys? Hold on. Thank you for doing that. I'm going to send 5 now. Listen, I'm the nice one, and I'm going to say this. I'm going to gift 5 memberships in a bit, and then I'm going to gift all 10 today, because sometimes I forget to do it. If you do not want for people to see that you are lurking in the bushes, turn it off to where you cannot accept gifted memberships. Okay? That's all I'm going to say. I lurk in people's bushes sometimes, and I don't necessarily want to be seen. There's times I lurk, and I don't care if I've seen. I'm just not chatting because I got shit going on. All right, so let me do this. Oh, hold on, that's wrong. Close that. Let me do this. All right, I'm sending 5 memberships. So welcome all of you. I need to start focusing on doing things for our members. I just don't know what it would be. I know that once we start getting close to the trial, if this goes to trial, again, y'all, this doesn't mean this is going to trial. There's still things that can happen. Do I think it will? Yes. Do I think it's projected to go to trial? Yes, I personally do. Under what terms? We don't know exactly. Is the jury going to see these 212 statements? Probably not. We don't know what's going to happen. Katie is still arguing that. Thank you, Skynet, for another. Hey, Leanne. Leanne, welcome. Welcome. Welcome, welcome. Oops, hang on a second, y'all. What am I doing? Here, I'll play this one for you, Skynet.
It has not been filed in court. If you are a YouTuber and you are talking about this case, you did not get it from me. You got it from the cult.
Leanne, you weren't around for that, were you? Oh my gosh. Oh my gosh, Leanne. If you weren't around then, so do you know that story? So the day that she was served, okay, April, so she was originally, okay, y'all, anybody that doesn't know the story, it's fucking hilarious. Okay, so April 5th of 2022, she was served. Well, I know you know who Emily D. Baker is, right? So Emily D. Baker and another attorney, uncivil law, they were talking about the lawsuit Katie Joy was in previously with Toddy Westbrook, and I think they talked about the Todd Chrisley lawsuit. Anyways, it was filed in court. She got pissed off because Emily D. Baker and uncivil law were talking about this lawsuit that was filed in court. She gets on there. She looks like shit. She's all red. She says she has COVID, and she's losing her shit. And she's shaking the paper, and she's like, whoever has this got it from the cult, because this has not been filed in court. This is only pocket service. This was not filed in court. You got it from the cult. It is epic. It is hilarious. It is hilarious. I'm going to play that again.
It has not been filed in court. If you are a YouTuber and you are talking about this case, you did not get it from me. You got it from the cult.
It'll never get old, y'all. It'll never get old. Oh, man, it was hilarious. I've got to find those clips just for you. Yeah, I bet you remember that, Purple, because you were around. I know that you were around big in that, like watching a lot then, weren't you? Oh, my God, it was hilarious. And then she starts going after Emily D. Baker, hardcore. And now look where Emily D. Baker is. Emily refuses to say her name. She will not say her name. She calls her that YouTuber, just like Todd Chrisley. It's hilarious. Okay, so let's get into Jennifer Morris, because this is funny, y'all. She's basically saying she's a licensed attorney, that represents Katie Joy, and that she attached here to as Exhibit A is a true and correct copy of a special verdict form. Okay, y'all, this is just unreal to me. Okay, Leanne, if you're still in here, yes, please, once I get to this, please help me out. Please help me out, because my brain is like, what the fuck? But correct copy of a special verdict form, demonstrative prepared by counsel for defendants. This exhibit is offered to illustrate the jury unmanageability of this action in its current form and is not a proposed verdict form for actual use at trial. It identifies, conservatively, more than 1,300 discrete findings a jury would be required to make before reaching the question of damages on the claims as currently pleaded in plaintiff's second amended complaint across all 8 counts in the statements identified in this action. Okay. Basically, it was Jill B. It was epic. Yeah, I call her without a clue. I'm going to go ahead and, you know what? I'm going to gift these other 5 memberships before I forget. All right, let's see who gets them. Again, sorry if you are watching the bushes and don't want to be called out, but hey, everybody, welcome. Chicky Chick, Slot Lover, All Nighter, Vicky, and Purple. Oh, it was so funny. Yeah, no, we got it from the court. It is filed in court, you dumbass. Oh, it was hilarious. So Katie Joy's attorney puts together this. Let me just scroll down real quick and show you real quick so you can get ridiculous thing here, okay? Like 50 pages of this. Okay, we'll go through it in a second. Leanne, help me out here, please. But anyways, it's her demonstrative. It's based on my review of the Second Amendment complaint filed June 4, 2026, the court's June 23rd, 2024 order granting the in part defendant's motion for summary judgment, the court's December 17th order on reconsideration, and the statement by statement analysis set forth in the tables attached to defendant's memorandum of law. But again, we don't have this memorandum of law yet because it's not been filed. I'll look again here in a minute and see once we get through this. But basically what she's saying, this is my, you're welcome. Basically what she's saying is, look, judge, this is just way too much for a jury to handle. There's too many statements that my client made that are so fucked up, that are so clearly defamatory, right? Just way too many. It's going to overwhelm a jury. They're not going to be able to sort through it. It's just too much. There's too many counts, right? So not only do we have all these statements for one count, we've got it for, possibly 8 counts. This is just too much. And in my calculation, Judge, my calculation states that each juror is going to have to go over 1,300 separate things. That is just too much for a jury, Your Honor. That's literally her argument, y'all. That's literally her argument. She did math. Yeah, she's not only saying it that a jury, I don't know if she's trying to say the jury's too dumb, it's just too much. I kind of look at it like, Your Honor, do you not see what you've done here? Do you not see that by you granting this amended complaint, granting this motion to amend the complaint, do you not see that by you granting that motion and then filing this amended complaint with 212 statements, do you not see what you've done to a jury? Do you not see what you've potentially done to this case? Do you not see how bad you've made it? Not hey, my client is a fucking idiot. She can't keep her mouth shut. She's called him a serial rapist. She said that he absolutely, with 100% fact, is running a sex trafficking ring, that he is essaying Miranda, that James sits by and watches while he essays Miranda. Forget all those things. Let's just not let the jury hear it because it's going to be too overwhelming, y'all. Judge, do you know what you did? Your Honor, you're an idiot. I cannot believe that you allowed this to happen, because now per my math, they have over 1,300 statements they're going to have to answer to, and she lists them all. All right. She puts them all in this handy dandy little bullshit. But anyways, we'll get to that in a second. But it's based on all this bullshit. Okay, then she says, Minnesota Rule of Civil Appellate Procedure 136.01, Subdivision 1C, provides that unpublished opinions of the Minnesota Court of Appeals are not precedential, but may be cited as persuasive authority, and that, if cited, a copy shall be provided to the court and all parties. In addition, as a matter of professional practice and out of an abundance of caution, I am attaching copies of all unpublished or non-reporter opinions cited in defendant's memorandum of law so that the court and opposing counsel have ready access to the full text. Okay. Again, we don't have the memorandum, so we can't compare that. Is it okay? So I'm not the only one that finds this wild, Leanne? Like my unprofessional opinion of this. Okay, I'm glad to know that it's not just me. It kills me. Okay. Basically, so I mean, yeah, she's literally saying, y'all, that the Second Amendment complaint, this amended complaint, the Second Amendment complaint, has become so large and complicated, and the way the claims, are pleaded would require, the number would be so ridiculous that for a jury's findings. And so she gives an example as to what all this jury would have to answer to. So Miranda says, how likely is the judge will grant this in KJ's favor? And Leanne says, I think very unlikely. And I agree. Now, again, it's going to depend on how the judge rules it. Is the judge going to say, I deny all of it, and then Katie has the opportunity to do that appeal, right? And then, or I don't think, Leanne, she'd be able to file another motion for summary judgment, would she? Because the way that they word it is, if you don't think anti-SLAPP applies, then to rule it by the standards of a summary judgment. So I think they're kind of knocking it all out, because the deadline for her to file the word is totally escaping my mind. Her dispositive motion was August 31st. So she wouldn't be able to file another, right? So I don't see how that would work. And the judge, this judge, I think, is wanting to get this completely. I think she wants this done, and she's going to do what she can. So it depends on how she rules on it, right? Like where this is going to go. My guess is, and Leanne agreed with me, so that's good, that she's going to, grant in part and deny in part, just like she did summary judgment. Yeah, if a jury has to assess 1,300 statements, then they have to assess 1,300 statements. That's their role as a jury. Like so let's say in a criminal case, right? Where somebody, this atrocious unaliving of somebody. Oh, I'm sorry, Judge. Your Honor, I just think it's too hard for a jury to have to see any of these photographs. So we're just going to take all these photos out. It's too much. It's too much. That's a jury's role. That is their job. Yeah, Katie Joy can't be nice, and she always thinks someone is after her. It does seem that way. Oh, you did, Skynet? Yeah, I mean, it's bogus. You have to listen to everything. Yeah, exactly. The Alex Murdaugh case, for example. It took a month, Skynet. Did you enjoy being on it, or was it something that was very traumatic? I'm 50-50 on whether I would ever want to be on a trial like that. All right, so we'll skip through her demonstrative bullshit, okay, whatever, of how this is going to be way too difficult for a jury, way too overwhelming. It's way too much, and by her math, it's over 1,300 things that each juror is going to have to consider. Okay, then y'all, this is where my jaw hit the fucking floor. Okay, I would love to hear feedback. Attached here too, as Exhibit B, is a true and correct copy of Conlon versus, I don't know how to pronounce their last name, so I'm just going to say Shea. Okay. This was so it went to the appellate court in March of 2026. Okay. And this is unpublished. This opinion is cited in Section 2A of Defendant's Memorandum of Law as persuasive authority. So she's just really attaching this persuasive authority. Okay. For the proposition that a defamatory statement added in an amended complaint does not relate back to an original complaint. Okay, so we've talked about this before. Let me just remind y'all, or for those that are unaware, or those don't give a shit, whatever it may be. One of Katie Joy's other arguments is, okay, these new statements, these new 212, actually it's like 138 kind of new ones, whatever. If you really look at them falling in within the anti-SLAPP, let's call it 138 out of this 4 categories, whenever earlier, if that makes sense. So these statements that were made that should fall under anti-SLAPP, okay, it's at the judge's discretion whether or not they relate back to the original claim. If you start adding other parties, if you start saying okay, well, we only were talking about her saying stuff on TikTok. Okay, the lawsuit was only about her being on TikTok, but now we're going to say that she's talking about YouTube. Okay, more than likely the judge is going to say, no, that doesn't relate back. Okay, the original complaint is about TikTok. Now all of a sudden you're saying YouTube and you want to bring in all these statements she said on YouTube. That doesn't relate back. Okay, that could be the situation where it doesn't relate back. Okay, once we're done with this, I want to pull up where the judge already kind of ruled on this to some degree, where she basically said she felt like, obviously, yes, it met those standards, and therefore she granted the motion to amend the complaint, right? If that makes sense. But y'all, this blows my mind. Okay, this attachment blows my mind. They're saying that they're using it as an example of where a case was sent to a jury and the jury saw all of these statements, maybe 1,300, who knows? Because that's a whole lot. I doubt any other judge would ever allow a jury to have to sort through 1,300 statements total by their math. But they're saying that in this particular case that they referenced from Virginia, okay, under a completely different statute. The statutes really don't even compare. This is a Virginia statute versus Minnesota statute, okay? But nonetheless, she just wants this judge to know that there is a case where somebody called somebody a rapist. They also called him a child molester. I have to be careful with the words I use, y'all. So grapist and molester, okay? They're family members. A sister and her wife ultimately called her brother, his brother-in-law, a grapist and a child molester. Okay? It went to the jury. The jury listened to everything. They made the ruling and they awarded the plaintiff, the brother who was being accused of the things, like I think in total it was like over $3 million, and then because of some limit it was decreased. Okay, they appealed it. Okay, the defendants appealed it, and under appellate review it was determined that some of the statements that were made did not relate back. For instance, one of them, when they first came out with the original complaint, they were saying that they said these statements to members of a church, or maybe it was to the members of their family. Let's just say it was to the members of their family, okay? When they did, and they did 3 amended complaints. So by their 3rd amended complaint, which is what the jury saw, they say that the defendants were talking to their church about it. Another thing they sent for appellate review, they sent to the appeals court, was that it was the sister that called her brother a grapist, okay? And that the brother-in-law was the one that called him the child molester. In the 3rd amended complaint, it was worded differently. Okay. So, and there's some other things too. I'm just giving you the examples I remember because I read the whole thing. It was fascinating, I thought. So the appellate court says, yeah, these questions that these statements that the jury ruled upon should not have, because number one, they're time barred because the same kind of thing with statute of limitations applied. And they didn't relate back because they were said to different audiences. Okay. In this case, Katie Joy saying to the same audience, it doesn't even relate. Like it's not even parallel. Okay. But she's trying to say, look, judge, here's somebody else that called somebody a grapist. Called somebody a grapist. They were awarded millions of dollars. The plaintiff was awarded millions of dollars, but it was a waste of the jury's time. because it just went to the appellate court and the court ruled that they never should have heard those statements anyways because they didn't relate back. They did not apply. So let's scroll down. This is her illustrative special verdict form. It's her demonstrative exhibit. I get tongue-tied with that word too every time too. To defendant's memorandum of law in support of special motion to dismiss. Okay. She's basically saying here that in the original complaint, there are 12 statements that were left over after summary judgment. That's not 100% factually true, but okay, whatever. And so then there's going to be 12 questions each. That's 120 findings. Then the pincer gap, which she's saying is between those dates, where the statute of limitations would apply, and also like after she was served. There's 7 of those statements. There's 70 findings. But then, look, Judge, you're an idiot. Like, now, look what you did. You just allowed another 1,130 findings for all these publications that, or statements that were said after the new anti-SLAPP was put into motion, right, or put into effect. Look at you. Now look what you've caused. You've caused 1,320. Can y'all still hear me? Why does this feel so childish? I guess when you have nothing else to argue, I don't know. Yeah, you can hear me. Okay. So here they all are. If y'all want to go back and look at this, feel free. But this is group 1. Remember, Katie Joy went over these groups as well, talking about the first one, the original 12 that were in this, blah, blah, blah. Okay. Then here's all the questions that the jury would have to answer to. Okay. And then you go down to all these statement numbers. Okay, so it's all the statement numbers, all right? She literally went through, and I guess you just have to take my word for it, okay? Went through and showed what each one that this jury would have to. How much did this cost Katie Joy for her to put this shit together? How long did this take for her to put this together? How much did it cost you, Katie Joy? How much did this nonsense cost you? This demonstrative bullshit. How much does this cost you, Katie Joy? So we're not there yet. We're still not there. We're still not there. We're still not there. We're still not there. Are we there yet? We finally got there. Here. Okay. If you want to go back and look, these are the questions that they put under each one that the jury would potentially have to, be so confused over. Here's the case. All right. If you're interested in a case number, if you're interested in reading this case, but I read it. Basically, I find it interesting. Let me tell you why I find this so interesting. I find it interesting. All right, Skynet. A fortune, Leanne says. And what's the fucking point of it? Pardon my F-bombs today, but when she makes me so crazy like this and so funny, I can't help but cuss. So this, what I find particularly interesting in this, and Leanne, I'm curious about all of y'all's thoughts. Why would she choose a case that the statute for, like when I read the Virginia statute for limitations on defamation, it's 1 year. Okay, so the statute's not even the same there. Also, when it comes to relating back to the original complaint, the statutes are different. Okay, so they differ. It's not even the same statute about an anti-SLAPP and relating. It just, I don't know. But why would she choose one where the defendant is accused of calling the plaintiff a rapist? Why would she highlight that? Why would she use this? I'm sure there are plenty of other case studies, plenty of other references that she could have used to show that something was related back to, that something was sent to an appellate court and they determined that the statements that the jury saw after an amended complaint was filed did not relate back. This cannot be the only one. This absolutely cannot be the only one. Purple Dragon Shield, thank you so much. I appreciate you. Thank you for always being the reliable source for Katie Joy legal shenanigans. I can't believe it's 4.5 years since this lawsuit started, and it's taken me. How cray cray. Yep. Yep. Yep.
Thank you for the love and the money while we keep covering this dummy. It keeps this little channel growing so we can keep this crazy going. From the bottom of our hearts, we love you so dang much.
And thank you again, Skynet, for gifting another membership. Appreciate you so much. Thank you. I need to come up with more little. I'm running out. What else do we have here? Let me see. This is AI. Sad that I have to say this.
I am all about ruining your life and laughing at your frivolous lawsuit you think you can file against me. But my legal team is the best dream team around, so good luck with that. But if you say anything about me publicly, I will scream victim faster than I will slam this bottle of cheap Spanish red. Wait, I drank my last bottle for breakfast.
Leanne says, I think the wording choice is chosen to cover her most severe statements. It's unpublished and from a different state. Sounds like she couldn't find anything more relevant. Exactly. But why would you want to highlight that word, that statement? Because it's not like the ruling in this was like, oh my God, that's so bad. Like, how can you call somebody that? The only reason why it was overturned was because of a deadline that wasn't acknowledged prior, right? I mean, why wouldn't you find another one? Why would you use the ones? Why would you highlight that you're calling him this? And this is why. So the last hearing they had was February 9th in person. So all parties had to be there. So that's the first hearing they had where all parties were there because it was a pretrial conference, right? That was February 9th. Katie Joy has not spoken since then. She went back after the hearing. She knee-jerked like she always does. She did a YouTube video where she basically says, they're trying to frame me. They're trying to get the FBI to arrest me. They're saying that I'm responsible for Robert Shin's FBI raid. If something happens to me, I was framed. And then she says, they said that I am making statements about Robert Shin as being sexual crimes in nature. She goes, I've never accused him of any sexual crimes. She said this in her YouTube video that same day as that hearing. And she also said, I've never said I was a victim of Robert Shin's, but she has. I even did a video that showed it where she said in 2 different places, I am a victim of Robert Shin's. So something was said during that hearing. I don't know if something else is done on the outside of this civil aspect of it. I can only guess. Okay. I'm not saying anything like that. By the way, if y'all haven't hit the thumbs up, please go out, hit the thumbs up, come right back in, please. I'm not saying that, but what I'm saying is something obviously happened to where she knee-jerked so bad that she had to go make a video and say, if something happens to me, I was framed. And that he's accusing me of X, Y, and Z, but I never said that. But she did say it. She said it, and it's clear as day that she said it. So I don't understand why she would use that one. She's included this case to continue her question 2 arguments on statute of limitations. Yeah. For it to exactly, that's what I was saying. It's like, okay, so what she's saying here is, right? Correct me if I'm wrong, but yeah, what she's saying here is they were out of the statute of limitations. They did not refer back. The jury never should have heard this. That's why it was overturned by the appellate court. And so this is one of the questions, and thank you for reminding me of that, Leanne. Remember those questions that Katie Joy is saying, hey, I want you to certify these questions to the appellate court. There's 3 questions. This is kind of relating back to that one. So what I'm seeing, and I'm guessing, Leanne, do you agree with me, is that she's setting now, she's like paving her way to be able to appeal this. Because if the judge denies this special motion dismiss. Now she's saying, okay, then I want you to look at under the precedent of summary judgment and dismiss it. And then if not, blah, 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 like we still, under the anti-SLAPP statute, still have the right to appeal. I just found this one crazy to me. And I understand why she used it, because she even says, and Jennifer Moore says that. Which one's hers? Let me see. Jennifer Moore says that, where she says, at the very beginning, let me go up to the very beginning. I don't know why I just did that, y'all. I just made my job a lot harder than what it should have been. She says in the beginning that, she wants to be cited as persuasive authority. Y'all, I don't know. It just, as persuasive authority for the proposition that a defamatory statement added in an amended complaint does not relate back to an original complaint where the newly specified statement is substantively different. And so again, kind of like question 2 also, where she's saying, hey, I want you to make sure that if we make a statement, if you're including a statement in this new amended complaint that was in the original statement, but it's been reworded, does that apply? And then also, I don't know. I can't wait to see how this judge rules on it. Like, my brain's getting scattered now. I can't wait to see how this judge rules. Leanne, what is your best guess on this? Yeah, she's laying the groundwork for appeal for sure. I think she may actually be anticipating losing this case. I do too. I do too. And I think that's where it's like her back where we were looking. I'm going to go back. So I'm going to sign back into this again real quick. Hang on, y'all. I'm going to see if they've corrected their error here. If they have, we're going to have to go live another day and cover it because I'm going to have to read it anyways. All right, let me do this. Okay, so that's that. I just found it wild. I found this wild. How many pages was this again? 63 pages of bullshit. I think she's recognizing she could lose this case, and she has to have a backup plan to appeal it. She screwed up. She screwed up. And this is what I was going to look at. Let me do this first. Actually, let me go back here real quick. Let me unshare. So if we go back down here, make sure I'm on this right. Am I on this? Yeah. If we go down here, you can see on the 27th, she filed a notice of motion, but that memorandum was never filed. Nothing was filed. Then again, on the 11th, she filed a notice of motion, and that was amended to where she added these kind of things to, regarding the amendment. That's pretty much what the difference is. And we went over that. See, when I click on, y'all aren't going to be able to see it, but let me just make sure. When I click on this, let me make sure it's still. Yeah, when I open that, that's still her 12th declaration. So that hasn't been corrected yet. So just, hey, Goose. Yes, you did. You missed the entire live. 2 hours and 22 minutes of it? No. What time did I start? Oh, I started at 11:30, so almost 2 hours. One thing I want to do before we end, I want to show y'all something. I am sweating, y'all. It is so hot outside, and I guess my AC kicked off. And now I am oh, Goose, you were waiting for me. I'm sorry. You thought I was going to go live later. I'm sorry, my friend. And once again, your name is not in green. I gifted 10 memberships, and Unitopia gifted, I don't know, quite a few. Thank you again. And for all of my gifts that were sent, my super chats, my memberships that were gifted, I appreciate all of you. Okay, I'm going to show one more thing. Let me see. Stop screen. Share screen. I got to find the notice order granting motion. I think this is it. Share. Let me make sure. All right. So taking everything into consideration that we just spoke about, Goose, you're going to have to go back and re-listen to it. I wish I could do it in a nutshell. I don't know if I can. I don't know if I really can. Goose, basically, so Katie Joy filed. Okay, so what I said to you in a comment the other day, no, I did not talk about that. I'm not going to talk. There's something I found out, y'all. I was told something, but I don't see it reflecting on the docket yet. It's not about, and it's a change. And I'll let y'all know once it's on there. So if you see a change in something when it comes to 7M, don't panic. Don't think it's a bad thing. I will go live and we will talk about it. Okay. Thank you so much, Snoopy Jones. Jill B, thank you so much. I appreciate the jewels. Jill B, I appreciate you. Thanks for all you do for us, JJ. You are welcome.
Thank you for the love and the money. While we keep covering this dummy, it keeps this little channel growing, so we can keep this crazy going. From the bottom of our hearts, we love you so dang much.
Okay, so we're going to go back real quick. Thank you again. I appreciate y'all. Hey, short order cook, you made it. Y'all, and I started a lot earlier than planned because my husband's home. He's working from home, and so I needed to kind of be out of his hair later. Okay. Let me see something real quick. All right. Hey, Bean, you've been in the bushes. I had to take a break from prison calls. Prison calls, Bean. Wait, what, Bean? Did you see Charlotte on the web found calls about KJ? When did she put a video out about that? I have not been online. What? What did I miss, Bean? Goose, what did I miss? Y'all fill me in. Hold on one second, y'all. I mean, I gotta mute for just a second. I gotta answer something real quick. Hold on. Okay, I'm back. Now I gotta gather my train of thought. I'm probably gonna be on max another 30 minutes. Because I've already been on 2 hours. Spill the beans, ladies. You didn't hear those calls about KJ. I only heard Christy talking about Fancy going to KJ. Oh, okay. So it was, so so the prison calls that somebody got about Gypsy Rose, did they mention Katie Joy in those? Was Katie mentioned in those calls? Okay, so let me make this bigger. Y'all, this is a long one. I'm trying to remember where. Okay, so so Goose. So Katie Joy now, she filed her special motion to dismiss. Okay, so what I was saying earlier is that at the end of June, she filed a special notice of special motion to dismiss. Notice of motion and motion, but there was no memorandum. Remember, we talked about that. We're like, well, I can't read the memorandum. So yes, on the 10th, she filed another motion, notice of motion and motion. She filed an affidavit. Her attorney filed an affidavit, and she filed a proposed order. Okay, where basically she's saying this needs to be dismissed, all of it with prejudice, right? And I want attorney's fees awarded. But the memorandum is not showing. Instead, where it says memorandum, when you click on it, it actually shows Jennifer Moore's affidavit again. So there's an error there. So I've been talking about things that were filed, what Katie Joy's strategy is, type thing. We expected her to file this motion to dismiss. I mean, it was expected. I think that she's realizing she's totally screwed. She's laying foundation to be able to appeal this, which is, I think, smart. I think it's all she has right now. Do I think her attorney came up with this? No. I don't know. I'm just being an asshole. So I have my opinion. I'm allowed to my opinion, right? Bye, Christine. Have a great rest of your day. So yeah, it's kind of hard for me to put in a nutshell. But one thing that I wanted to point out that we were kind of talking about before, Katie Joy is saying this doesn't relate back, right? And then we saw what Jennifer Moore had in her affidavit, what her attachment was of her saying, look, we're just going to appeal it, and the appellate court's going to find that, I mean, I don't think this is exactly what she's saying. These are my words, okay? We're just going to appeal it, and they're just going to find that the jury wasted all their time because they're going to determine that it didn't relate back. But none of it is parallel to Katie's story, to situation. Like, it's just wild to me that they even put that in there. And I understand why they did, and Leanne was kind of saying that too, but you're looking at it from my viewpoint, it's like, what? But they're kind of saying like, okay, we're laying the groundwork for this. I don't know. It all just blows my mind. Because they're relying on the fact that they're going to say, okay, look, it doesn't relate back. So this isn't going to go anywhere. But we have to remember that the judge has already kind of ruled on this in some degree. And she even says here, I've got to find it, y'all. This is where she granted the motion to amend the complaint. Okay, so this is going through it all. She says somewhere in here specifically that Katie Joy has not stopped okay, so here she says, the court finds that amendment is appropriate in the interest of justice. The proposed amended complaint involves the same parties, the same alleged conduct, and the same causes of action. The court contemplated the possible amendment of plaintiff's complaint in the December 17th, 2025 order. So basically what she's saying here is, because the standards of if it's going to relate back are, does it involve the same parties? Is it the same alleged conduct? And it's the same causes of action. The judge is saying here, when she granted this motion to amend the complaint, that it does relate back. Now, with the knowing that Katie Joy is going to argue it, and she's going to argue certain statements, right? But basically, it's not like this judge is just like, yep, I'm granting it, and didn't consider what the original complaint consisted of, all the things, right? Does this relate back? Because Katie Joy already used this argument that doesn't relate back. Then she says, furthermore, Katie Joy has continued to make alleged defamatory statements against plaintiffs. Hold on. I just lost my place because I switched screens and that was dumb. Against plaintiffs since the filing of plaintiff's amended complaint filed on April 7th of 2022. Because keep in mind, she was originally served on April 5th by just Robert Shin and 7M. Then the first amended complaint came on April 7th of 2022, where they added James and Miranda Derrick as plaintiffs. By allowing amendment, the court makes no findings regarding the merits of plaintiffs' claims to those statements. However, the court finds that it is in the interest of judicial economy to address those statements in this lawsuit, given the time already expended by the parties and the court in this matter. The court has solid understanding of the parties, facts, and claims asserted. Were plaintiffs to file another lawsuit against defendants regarding subsequent statements, it would be a further strain on judicial resources and time. So this judge is basically saying, yeah, it fits all the things that it needs to at this point. You can argue it afterwards. I'm granting it. This court acknowledges that Katie Joy has not stopped talking, that there are other statements that have been made that 7M claim are defamatory, and that if they didn't grant this, 7M would just turn around, because they're going to grant it with, with prejudice, so they'd be able to do it again, right? They would just turn around and refile another lawsuit on her for all these new statements, which Katie Joy would file an anti-SLAPP, right? Blah, blah, blah. But nonetheless, the court is saying, we're not even going to entertain that. It all needs to be done right here, right now. So this judge, in some ways, has already addressed some of this. Additionally, Katie Joy has not demonstrated prejudice sufficient to justify denying the amendment. Okay? The fact that defendants will have to defend against these additional claims does not establish prejudice. Furthermore, the parties have yet to comply with the court's discovery order entered on January 29, 2024, and this matter has not been set for trial. So I'm assuming, and I was talking to somebody about this the other day, that Katie Joy obviously has finally submitted, that they've obviously come to that all of their issues with discovery have been settled, possibly, and that Katie Joy has finally provided her tax records. Okay, so now I'm going to take this off the screen, and we'll just do this. All right, so does that all make sense? Have I overwhelmed y'all completely? Yeah, right. If Katie Joy didn't run her mouth so much, it wouldn't be so much for the jury to hear. Right? I mean, it's like, what do you expect? But, when you're at this point, and like Leanne said, it almost seems like she's anticipating that she's going to lose this in some ways. Skynet, thank you again. SD, welcome to our members. Again, I got to figure out what I'm really going to start doing for our members with this channel. And I know that I really think this is going to trial, y'all. Again, on what terms, what all it's going to entail, we don't know. We have to wait to see what the judge is going to rule on this. What's her ruling going to be? What's Katie Joy's reaction going to be? What is she going to respond? What's going to happen? But another thing that we don't have right now is the memorandum. It has not been filed. Thank you, Skynet. Yeah, Goose, she's trying. She's trying. Goose, I'm just gonna start just mentally seeing your name in green because I don't know why. I don't know why this is happening to you, my friend. The memorandum has not been. I mean, now if there's somebody in Minnesota and there's somebody who's close to that court, to the Wright County Courthouse, that's able to go into the kiosk and get the documents, I'm pretty sure it's probably there. But as far as being online, I don't know. It's not showing. So if there's anybody in Minnesota who ever goes to the courthouse and they're able to get the documents, they would be able to see this probably. Okay. Catch my drift? Just saying. I'm a little too far away from Minnesota right now. Mentally, it's green. So, I know that as we get closer to this, and once we know it's going to trial, and once all that's happening, I'm going to start doing a lot of things for members. And I think, Leanne, if you're still listening, how long do you think? Okay, if you think this is going to go to trial, when do you think this would be set for trial? And when do you think it would actually probably get to trial? And then I'm going to be ending this in a couple of minutes. I've been talking for 2 hours. Again, I'm going to have to go live again whenever the memorandum shows. I'm able to view it. I'm able to read it and see I think we can tell pretty much from the documents we've seen what her argument is, right? But there's obviously stuff we're missing. And so I can't say all this stuff with certainty. I can't say anything with certainty anyways, but, without having that memorandum. Yeah, they're going to be able to show how KJ amped it up. Big time. The News Nation thing, y'all, that alone is bad. Both times she went on News Nation. It is long overdue, Goose. You think it will get to trial. I'm not sure when, but I think the judge, like us, wants to move on with this as soon as possible. Yeah, that's the same thing I'm thinking. So let me ask you this, Leanne. Let's say the judge denies this motion. Let's say she grants in part and denies in part. Okay, let's say some of the statements, some of the whatever, under certain claims. Let's just say some of it's put out, some of it's going to stay. How quickly do you like? I don't think I fully understand how quickly under the I think it's 30 days under the anti-SLAPP, she can file an appeal on that ruling. And the only reason why she can file an appeal at this stage is because of the anti-SLAPP statute. Do I have that correct? And if so, do you anticipate to see Katie Joy filing an appeal now? Or is that something she has to wait for if this judge sets this for trial? That's my last question. I'm just curious if I'm understanding this correctly. The timing on when she can file an appeal. I understand that the statute allows her to at this stage if the judge denies it or even denies in part. But when would that appeal happen? And what would it likely look like? There was a person following the case in Minnesota on the ground and KJ blasted her harshly. Yeah, I think I know who you're talking about, Jill B. It's their right. Katie Joy stalks everybody, puts out, all she does is talk about lawsuits and public information and stuff. So I just find it so irritating that if Katie Joy can do it, why when somebody goes to do it against her and to talk about her cases that are all public information, how can she, and then dox them and do all these things? It just blows my mind. I don't know. That'd be something interesting to look into, Maya. I have to read more on that, but I can see her filing an appeal and doing it at the earliest point. So she has a talking point for her channel. I find it so interesting, Leanne. She has not spoken since February 9th. There's something else that's about to come out. I was anticipating it to come out the beginning of this week to where we would see it. You're going to find it very interesting, Leanne. And I'm going to have lots of questions for you whenever, hopefully you'll be able to join my live whenever I do that. I'm not going to talk about it right now because I don't like to talk about things I cannot prove. I don't like to start shit and then be like, I have to go back and fix it. Plus there's going to be, kind of a lot of details behind it that we'll have to see in documents, right? We'll have to see in filings. We'll have to see understandings. We'll have to see motions, and notices. So there's that. So you'll be seeing me going live when that happens to talk about that, if it happens. Okay. Then also once we see this memorandum show up, and then also, we're just going to do our typical lives where we're going over the statements that we left off at on our last live. Is today Thursday? I'll probably go live tomorrow. I'll schedule a live tomorrow. I'll probably do it the same time I did it today, earlier in the morning, around 11:30 Central Standard Time, same time I did today. Okay. And if the memorandum has been filed and it's viewable, we'll discuss that. If some other information comes out, we'll discuss that. But if not, then we're going to continue going on with these statements, because I'm telling y'all where we're at right now. And they're the same ones that were in the video that just went through, but I can give more of my input on them in a live stream. I like to do it both ways. So I will go live tomorrow. I'll do it around the same time. Oh, it's okay if you've named her. I mean, because people know. I'm just not going to say who. And it's fine. I don't even know if she's still on YouTube. I'm just reading chat, y'all. That's why I said that, Goose. I'm like, anybody else that's out there that wants to, because I've had a couple people in comments that say that they live close by and that they've gone into the courthouse. So I'm just putting it out there. I want to know if it's a court error or if it's another Jennifer Moore error. I want to know how much this ridiculous demonstrative example bullshit that was 50 pages worth. I want to know how much that cost Katie Joy. Maybe Katie Joy did it herself. That's very possible too. I think some of us are on the same belief that Katie Joy does a lot of this stuff herself, and then Jennifer Moore either reviews it or doesn't, because sometimes it seems like some things haven't been reviewed, but then it's filed. So I don't know. It depends whoever did it. Johnny Depp's took 5 years. You're a short flight away from Canada. Flying to the U.S. has been crazy there. Y'all, we had 0 issues flying. 0. We were lucky. We weren't even delayed. We were looking up at the screens, and like all the flights, so many flights were delayed. Ours was on time. Ours was delayed by a little bit. We still landed. Y'all, by the time we landed, we were off the plane. We fly first class, but when we were off the plane, we deboarded. We were the first row, right? So we were able to get off very quickly and get our stuff. And my husband's like an ox, so he just carries all the shit, and my little legs try to keep up. We were in our car and at the parking gate, because we park in the very first lot too, like right up front there. So it was pretty quickly, but still, nonetheless, we were off the plane in our car outside of the payment area within 15 minutes. Within 15 minutes, we were in the car was started, and we were at the gate exiting the parking lot. We had 0 issues, but I've heard so many, and you'd see people in there and you could tell that they were changing. Like you would hear it all over the intercom that they were changing gates and all this. And I was like, oh, please tell us not. Because we had to have the rental car. But you know how that goes. You have to have the rental car back at a certain time. If not, if you're 5 minutes late, they charge you for a whole nother day. So by the time that happened, we were like, well, we got about 3 hours at the airport, which we don't usually mind. We sit and eat and sit at a little bar area or whatever, read, whatever. The rain has caused delays. Yeah. Plus, I just think, and I think it's social media too, because I get all nervous. Like you'll start watching like TikTok or Instagram, and you'll see all these fights breaking out on a plane, all this crazy shit where they're having to like land, right? Like land early or totally reroute and go land somewhere else so somebody can be arrested on the plane. You think Katie files everything herself? I think she does a lot. I could honestly, whenever I read this, I was thinking, okay, something else is going on here. They gotten advice from somebody else, maybe. I just don't see Jennifer Moore as being a competent attorney. I personally don't. That's my opinion. I could be wrong. I might see her in trial and she might blow all of our socks off. I probably won't wear socks to trial, but whatever. right? Therefore, she can't blow them away because I just don't know. I just don't know. But keep an eye out. I'm going to go ahead and schedule a live now for tomorrow at 11:30. I'll go ahead and put a post on my thing. Tomorrow, 11:30 a.m. Central Standard Time tomorrow. We'll go over whatever it is that we need to go over. Whatever happens before now and then, we'll go over. If nothing happens, we're going to keep going over these statements because I'm telling y'all, they are bad. They're so bad. I also put a video out 2 days ago covering the statements that we're going to start to go over in our live stream. We might make it through all of them. We might make it through more of them. I don't know. All right. So again, thank all of you for being here. I appreciate each and every one of you. Thank you for the super chats. Thank you so much for the gifts that you're sending. Thank you so much for the gifted memberships. I appreciate all of you. And hey, Christmas Lake. Good afternoon, Southern Mountain Chat. Finally caught it late. I know. I'm just now saying goodbye, Christmas Lake. Your sister made it through security. O'Hare into her gate in less than 15 minutes a day. Wow. Yeah, we got through security super fast. We're TSA pre-check or whatever. Man, we got through so fast. We were at our gate in no time. Both times. We had zero issues. Zero issues with the flight, with the security, nothing. And it was like, wow, well, how did we get so easy? And O'Hare, I hate O'Hare. I used to fly into O'Hare a lot. I haven't flown into O'Hare in about 4 years, probably. Thank you for being here, Leanne. And hopefully you can join us on the next one too. Welcome all of our new members. And I will see you guys on the next one. You guys have a wonderful day. Stay cool, stay dry. Those of you that are in Australia, stay warm, I guess. Yeah, KJ's lawyers should be embarrassed with all these filings. Yes and no. Yes and no. I'm just going to giggle and laugh because I think it's all ridiculous, but she's doing what she needs to do. And I think it's a product of Katie Joy not being very honest with her attorney, maybe. And with them getting too big of britches, thinking that this was going to go, that they even put it in a filing incorrectly that he had been indicted. Because they were anticipating that he was going to be indicted, that they actually put it in a filing and then had to amend it and be like, oh, we didn't mean to use the word indictment. We meant to use the word ongoing investigation. Like, that's how bad some of this has gotten. So they really thought he was just going to be arrested. He hasn't been. He's not in prison. And now it's like, oh, shit, what do we do? And the things that Katie Joy said, I'm wondering if her attorney is just now finding this out. I'm wondering if her attorney is just now finding out the things that were said when this amended complaint or the motion to amend the complaint back in November was seen. Because Katie Joy got awfully quiet in February. So, I don't know. We'll talk all about it again tomorrow. Appreciate y'all. Guys, have a wonderful day. And I will see y'all tomorrow, hopefully. Bye, y'all.
It don't take a crystal ball to know how some stories end. When someone keeps saying opinions like facts, the courts start listening. Southern Mutton don't predict nothing, we just watch and write it down. Don't need a crystal ball to see it coming back around. When you state it like a fact and never check it first. Southern Mutton, watch it close from the courthouse ground. True, stay patient while the paper getting worse. Same routine, new headline phone. Same bold claims that the record don't want. She speak real loud, no maybe, no seems. Turn opinions into facts like the courtroom clean. I ain't wishing nothing, I just seen the signs. When the words outrun proof, it's a matter of time. History repeat when you don't learn yet. Courts don't care what you meant, just what you said. When confidence louder than evidence be, that's when patterns start explaining things to me. Don't need a crystal ball to see it coming back around. When you speak like a verdict before the truth's found. Southern Mutton in the case, boots firm on the tile. We don't chase drama, we just watch the file, yeah. Country rap calm, I don't glow to grin. I just read the docket when it rolled back in. She called it truth, called it just how it is. But courts draw lines where the talking ends. I ain't psychic, I'm observing. Facts don't bend cause a voice is urgent. From testimony tone to the written page. same outcome when the pattern don't change. Lies like speed, truth like distance. One burns fast, one keeps existing on. Lies like speed, truth like distance. One burns fast, one keeps existing. Don't need a crystal ball, don't need belief. When the law still runs on proof and receipts. Southern mud and watching through the courtroom glass. Pointing out lies as they're saying it's facts. Yeah. This ain't prophecy. This ain't hate. Just history watching itself repeat. When words get reckless, the courts get busy. And the truth always shows up right on time.